two bodies. It looks like a backpack, but everything is separated. It's in the first section with the two bodies and three seats. But it's huge. Yeah, I stopped. Correct. I have no shoulder bags. I don't wear any pouch.
I spoke to the workers for a long time, and I picked out what I thought was really an excellent story about how when I was in R&D, how the stuff I like to find out.
Elliot Gerson.
Hello, it's good to see you again. Number 2 out of 3. We'll see you again next week. Yes. Yes, I was one of the founding people that I then, well, I couldn't write them anymore. I was in a movie for a long time, but I had to write them anymore because I had a carbon contract for this, and then when they started licensing broadly, that's right.
It's great.
Giving out the first ever Minow award.
Yeah. Another limitation. So.
This is actually really good at that. Very, yeah.
Good morning, everyone. We are delighted to be holding our first Georgetown Law Aspen Institute collaboration on matters of public interest and public importance. I'm Alex Zelenikoff, the Dean at Georgetown, and I want to thank Aspen and Elliot Gerson for being here, and I want to thank our panelists, and particularly Ken Feinberg for taking time out of his incredibly busy schedule to come and talk with us, and Clive Crook for being here as our interviewer. That's very kind of you. And my job here is simply to turn things over to Meryl Chertoff and let her take things away. Meryl is directing this program for us and has done a great job organizing today's event. Thank you.
Thank you, Dean Zelenikoff. I'm Meryl Chertoff, Director of the Georgetown Law Aspen Institute Symposium Series and Visiting Professor of Law at Georgetown, and co-director of the Justice and Society program at the Aspen Institute. Georgetown Law and the Aspen Institute are proud to collaborate on a series of discussions on issues at the intersection of law and public policy. This is the second of our collaborations. The first was the May 2009 Sandra Day O'Connor Project Conference on Judicial Independence in a New Era. It was so well received that Georgetown and Aspen decided to continue the partnership, and this morning's program is an example of what we hope to bring to the civic discussion. On January 26th, Justice O'Connor will join us for discussion of two major Supreme Court cases, Caperton against Massey Cole and the Citizens United case, which have profound implications for the way that state court judges are selected in the United States. It's an invitation-only forum, but if you're interested, just let us know and we'll be sure that you're included. The Justice and Society program at Aspen Institute has for 30 years produced seminars on justice and law, especially issues of human rights and humanitarian law. Its seminar schedule continues in the summer of 2010, and its programming will be expanded. If you're interested in its work, please visit the Aspen Institute website, www.aspeninst.org. We want to thank Dean Zelenikoff and Georgetown Law for hosting, and the Sandra Day O'Connor Project for co-sponsorship of today's event, and the Aspen Institute as well. I'd like now to introduce Elliot Gerson, Aspen Institute's Executive Vice President of Policy and Public Programs, and welcome to Georgetown.
Thank you, Meryl. Thank you, Dean Zelenikoff. Let me first say how excited we are about this new collaboration with Georgetown Law School, and I expect to see many of you and on similarly important topics in the months, and I hope and expect years ahead. I feel a little bit like that fellow in the Remington razor ad. We were so impressed with Meryl Chertoff and the work she did with Justice O'Connor, we just had to hire her, and we have done that, although it fortunately came with a tether to Georgetown. So we will continue to be doing many things in the future jointly with Georgetown, which we're delighted to do. As you all know, Ken Feinberg is the Special Master for Compensation under the Troubled Asset Relief Fund. He has said that the title compensation czar would cause his Lithuanian grandmother to turn over in her grave, so we won't, of course, call him that today. Instead, he is a distinguished D.C. attorney specializing in mediation and alternative dispute resolution, and, of course, now serving as special mediator extraordinaire, serving with a client and with interests and issues legal, economic, and moral that obviously have the country's closest attention. He's no stranger to difficult assignments. He was the Special Master for Compensation in the Virginia Tech shooting case, providing funds to the families of victims of that campus tragedy. Before that, he was Special Master of the U.S. government's September 11th Victim Compensation Fund. Originally from Brockton, Massachusetts, he holds a bachelor's from the University of Massachusetts and a JD from NYU Law School. He's been a federal prosecutor. He was chief of staff of the late Ted Kennedy. He's been special settlement master in cases including Agent Orange, product liability litigation, asbestos litigation, and DES litigation. His current assignment has required him to determine the proper level of compensation for the top executives at firms that received exceptional TARP assistance. Under the Emergency Economic Stabilization Act, the Special Master has a mandate to review all forms of compensation for the 5 most senior officers and the next 20 most highly compensated employees at the 7 firms that received exceptional TARP assistance. His assignment has put him squarely in the crosshairs of 2 conflicting policy goals: the importance of satisfying the American public, which is footing the bill for TARP, that their money is used equitably and judiciously, and, of course, the argument of the private sector that undercompensation of these top executives will not permit recruitment and retention of competent and creative top executive talent who will be able to stabilize those crucial American companies and keep them from falling back into the dire straits once the TARP safety net is withdrawn. Last week, the Treasury Department published the first round of Mr. Feinberg's findings and his letters of instruction to the first round of affected corporations. And, of course, there's been an understandable blaze of interest in the public and financial press for this. Also, it is my pleasure to introduce the person who is going to be quizzing Mr. Feinberg this morning. And that, of course, is Clive Crook. He's senior editor of The Atlantic, chief Washington correspondent of the Washington Times, and as I joked with him earlier this morning, he's virtually become a part of the Aspen Institute, because any time we have a program of significant economic consequence anywhere in the world, Clive is our first choice. He's widely regarded, and I think we all agree, as one of the leading journalists and commentators on economic and business issues in the world today. So it is my pleasure to bring up to the stage, and these chairs that look very comfortable, Clive Crook and Ken Feinberg, and I hope very much that you all will enjoy it, and there will be time for questions. Thank you.
Well, thank you very much. Thank you. I want to thank Georgetown Law and Aspen for asking me to do this. It's a privilege, actually, for me to be taking part in this conversation. And I think we've just heard that Ken has taken time out of his busy schedule. If anyone has an excuse to turn down an invitation like this, it's surely Ken Feinberg. He must be the busiest man in America, with only Barack Obama, I think, is the only plausible exception. So thank you very much for agreeing to do this. And I want to congratulate the members of the audience for your good sense in coming along to this thing. I expected the room to be packed. In fact, I wondered if I had to say yes to the invitation to do the interview, because it would be my only way to get into the room. I'm surprised to see these empty seats. Maybe there are hundreds of people milling around the building trying to find their way here. I don't know. But what we saw last week, I think, was enormously significant developments, both in Ken's announcement about his dispensation for the banks and financial firms that have received exceptional assistance under the TARP. But also, as you know, the Federal Reserve announced that it would be taking a hard look at compensation practices across the financial industry as part of its ongoing regulatory regime. It seems to me this is a seismic shift in the way the U.S. and the world thinks about these issues. That's what's going on right now. And the timing of this conversation, I think, it couldn't be any better. Okay, well, Ken, I thought, first of all, I could just ask you, I got so many things to ask, but maybe we could just get the ball rolling. If you could give us, a brief summary of what you actually announced last Thursday, what the content of your announcement was.
My announcement last week was my attempt to implement a federal statute and accompanying Treasury regulations, which were enacted by Congress and the Treasury. And the law said, as you point out, or as Elliot pointed out, the top 25 officials in just 7 companies, as defined by Congress, receiving the most TARP assistance, shall have their compensation established, determined by the special master. And so last week, what I did, after 5 months of discussion and negotiation and input from those 7 companies, I made determinations for 175 slots, the top 25 slots at AIG, Bank of America, Citigroup, Chrysler, GM, GMAC, and Chrysler Financial. That's the limit of my mandatory jurisdiction. And that is what I did last week in my report, which is available to everybody on the Treasury web. And there it is, the rationale for the actual dollars that I determined were warranted for those individuals.
Right. And that, if you read that document, it's very much a case-by-case rationale. That's really my first question. I mean, when you approach this issue, you must have had certain general principles in mind.
General principles?
But in applying them, I mean, the treatment from firm to firm is really very different. How did that process work?
To nobody's surprise, automobiles and banking institutions are vastly different in terms of their compensation. So what we did with the general principles articulated in the statute and in the regulations, we asked each company, those 7, to make comprehensive submissions of data, empirical data, anecdotal information about their individuals. And we evaluated very carefully that data and that information. And we met with those companies. And we asked for supplementary information. And eventually we synthesized all of that information with the law in mind and the regulations and came up with our determinations.
Okay. Now, I mean, there are, as Elliot said in his introductory remarks, there are some, as it were, contending principles at stake here. There's the public perception issue, and I think you've said this in a couple of interviews, that you had to deal with the public perceptions of the matter and respond to that. And then, as it were, there is the law and the economics of the matter. That's in there as well. But one element I wondered if I could get you to comment on that I'm particularly interested in is that there are two big things here looking strictly at the compensation side. One is level, right? The overall level. What is the total that these guys are being paid? And that is the focus, I think, of public interest or concern. And then the other is the structure of compensation. How is it structured so as to encourage, I guess you could say, to encourage better management or to encourage a more honest or accurate assessment of risk? So you don't want to incentivize undue gambling. Now, you had to, those are two separate things, aren't they? And I wondered how you kept both of them in mind as you took this process forward. I mean, was the main thing you were worried about actually getting these payments down because of the outrage they caused? Or was the main thing in your mind to sort out the structural defects?
Clearly not the former. We were in no way driven at all by the, quote, outrage, unquote. This is not a vindictive program. This is not punitive. That's nowhere listed in the statute. The challenge here was the other challenge you referred to.
Right.
How do you meld conflicting principles in the law? On the one hand, Congress speaks about the need to keep these companies in business, have them thrive, make them competitive, pay the taxpayer back what is owed. On the other hand, you have these principles that talk about changing the structure, that compensation should be more performance-based. It should encourage individual officials to remain at the company and thrive. It should avoid, compensation should avoid excessive risk, whatever that is. So, I mean, you have these general principles which I deem to be largely vanilla. I mean, it's pretty hard to oppose generic language that talks in terms of these principles. Yeah. It's applying the principles and trying to meld what is often conflicting signals from Congress. That's the challenge here. That was the challenge. And I think we did it as best we could.
Let me just press you on the claim, which I was a little surprised to hear you make, that this was nothing to do with retribution. Please. this whole exercise is something to do with retribution. I mean, there is a political dimension here, isn't there? The reason there's such intense interest in what you're doing is that people are outraged, and to my mind, not unreasonably, by the sight of, you know, bosses of failing companies who brought the economy down, continuing to enrich themselves. I mean, that's clearly a big part of what's going on, isn't it? I mean, you have to respond to that pressure. You can't ignore that.
First of all, to the extent that anybody talks about retribution, of vindictiveness, of punitiveness, I mean, look to Congress. They created this statute.
Sure.
I'm not riding into this on a white charger. I mean, my goal, my objective is to implement a law that was passed. I'm acting pursuant to Congress and pursuant to the Department of Treasury regulations. So be careful about bringing in this element of public outrage or passion when it comes to my individual decisions here, which I believe in my report are very principled. You may disagree. People may reasonably disagree with my conclusions, but I will defend my conclusions on the merits without regard to discussion about punishment, retribution. Those questions are better directed at Congress and congressional oversight hearings.
Right. Well, let me just drill down a little bit more on this.
I'm sure you will.
On this division I'm suggesting to you between oversight that looks at the overall level, the total level of compensation, and oversight that looks at the structure, as it were, the risk-encouraging properties of the structure. And let's take each in turn. On the levels issue, how did you think about that? I mean, or perhaps you want to say that the level, as it were, just came out as a residual once you tackled the risk-reducing side. I find it hard to believe that the level wasn't explicitly in your mind as an issue, as something that you wanted, as it were, to operate on.
The level of dollars in my report can be traced to the following methodology. We had a methodology, just like we did with the 9/11 Victim Compensation Fund. Let's get all of the empirical information we can get about marketplace value. What is this woman worth in her job at X? What does that man get at his job at Y? So the first thing we did was secure as much empirical information we could from the companies themselves about value. Then we sought out independent, additional information, empirical, from independent sources, academic consultants, others, that would help us better evaluate parochial submissions. Then we sought anecdotal information from the companies about individual worth on the job. This person, that person. So we gathered together as much empirical and anecdotal information as we could get, about 175 slots. Then we took a look at what is the 50th percentile. Half get more, half get less in that slot. And based on that information and the anecdotal information we came up with, we tried as best we could. It's not an exact science. We tried as best we could to come up with a corroborated, principled basis for locking people in at certain dollar levels. It's never been done before by government that I know of in a public program like this. So we were, it was uncharted seas what we were doing here. But you ask, how did we come up with, the first of your two questions, these actual dollar levels? We factored all of that information in. Now, the law spells out some interesting curveballs here. For example, after we come up with all of this information, the law says, well, what do you do after you have all this information if one of those individuals has a grandfathered contract for compensation? A contract entered into in 2007 that says that in 2009 she shall receive $2 million. Now, you've got all this information about 2009, but wait a minute. The law says I've got to take into account prior grandfathered obligations. And the law says I could do three things with those grandfathered obligations. First, find that obligation invalid. The contract's void. Now that is something I am loath to do. If the employee says the contract's valid, and her lawyer does, and the company says the contract's valid, backed up by Cravath or Sullivan and Cromwell, I'm not ready to simply say, change circumstances, the contract's void. So then the law says, all right, if the contract's valid, what do? Answer, in the law, attempt to renegotiate the contract. We were very successful in doing that. In almost every case, we convinced the company to take that grandfathered contract, don't enforce it, roll it over into 2009 stock, salarized stock, so that there won't be a skewed amount of compensation. Almost every company, patriots that they were, agreed to do that. Then the law said if there is a company that won't do it, the contract's valid, they won't renegotiate it. What then did the law say? The law said, well, in such a case, you will enforce that agreement, but you may take that agreement into account in setting 2009 compensation. And in one or two cases, we did just that. You want that money, you won't renegotiate, you're entitled to it. It's a mistake. It doesn't help the country. But if that's what you want, the sanctity of contract is inviolate, and we will take that into account in setting your compensation for 2009. So you asked for sort of numbers and methodology.
Right.
That's how it worked, basically.
But what does that lead you to conclude? And I don't mean this as a sort of trick question in any way. I'm not trying to, expose an inconsistency in what you're saying or anything of that kind. I mean, this is a naive question. So tell me what you think. What does that tell you about the way these decisions were made in the first place? If you bring that kind of analytical apparatus to this issue, if you say this has nothing to do with the government's notion of what would be the right level of pay. It's all based on market data. Look at what these guys are paying. Look at what those guys are paying. The implication of that is that this is what these firms should have been doing in the first place. And in fact, they weren't, because the alterations you've rammed down their throats are very, very large. So, I mean, what does that leave you to think about the way these decisions were being made in the first place before you came on the scene?
It leads me to believe that in the first place, these firms could have used some improvement in the way that they set executive compensation. It led me to conclude, secondly, that, as you implied 5 minutes ago, that there ought to be a different incentive-based structure for establishing compensation. The conclusions we reached, I think, vindicated by our report, is that both as to amounts of compensation and, more importantly, as to the elements, the structure of compensation, there is definitely room for improvement in both regards.
Right. Well, let's come to the structure. I've got a follow-up question on what you just said, but let's just come to the second part and the structure. Do you tell the audience, for those who don't know, what kind of guidelines you've suggested there in terms of the amount of cash, deferred stock, and so forth? Maybe you could just describe the shape of of those rulings, and then I'd like to ask you another question about the way that works.
The structure that we adopted has three components, virtually for all of the companies, with some exceptions, but the basic blueprint is the same for determining compensation. One, offer up much less cash to these officials. Reduce the cash salary component, the amount of total cash guaranteed twice a month as part of the contract. Reduce that well below the current levels. cash is diminished substantially, on average by 90% cash. Second element, make up a good portion of that cash diminishment in the form of what we call salarized stock. If you're going to make $500,000, here's $200,000 in cash that you get guaranteed twice a month for the 2009. Here's $200,000 in salarized stock, which you will get with your check, your cash. You'll get it at the same time, but it's stock. It's not cash. And that stock may not be immediately redeemed. You must hold that stock as long as 4 years before you can redeem it. You can redeem 1/3 of it after 2 years, a second third of it after 3 years, and the last third of it after 4 years. The value of that stock will depend on the value of that stock vis-a-vis the company. If the company's stock value improves, you may get a windfall. If the stock remains dire and in the basement, it may be worthless. But your total salary compensation is tied in large part to the relative long-term performance of that stock. And the third element, we will also give you, in addition to cash, and in addition to this salarized stock, we will also give you a chunk of long-term stock in the company. But that third element, that long-term incentive-based stock, will only vest after 3 years, so you better stay on the job, and even after it vests, it is only redeemable if the company pays back TARP and pays back the taxpayer. Otherwise, that stock is not redeemable. Even if it vests after 3 years, the company either repays the taxpayer or that stock cannot be sold. Now, that is basically, in a nutshell summary, the structure, the formula we used, designed, well-intentioned, designed to change the way these 7 companies compensate their high officials. No guarantees, no retention payments, no guaranteed bonuses, perks, no more than $25,000 per individual perk, private jets, golf club dues, country club dues, $25,000 per person. Beyond that, come to the Office of the Special Master for approval. That clawback by law. If in 2010 or 2011 you gave us false performance metrics, false material information, the Special Master and the company will claw back money already distributed. That is the overall scope, summarized, of the program.
The clawback thing you just emphasized, that's by law.
By law.
But the scope of that is somewhat limited, isn't it? I mean, it's false, as it were, false statements, false financial information.
Material false statements or I think it's material inadequate performance benchmarks.
Okay. Because what I was thinking was that if the company just turns out to do worse than was expected, then that does not trigger this clawback. That does not enable this clawback power.
Now you're talking like a lawyer. I mean, material false statements or material inadequate performance benchmarks. I mean, I don't know how we would interpret that. That's down the road.
All right. But anyway, that, as you emphasized, that part was by law. The other things you mentioned, how much of that was in the legislation that created your office, and how much was that of your devising?
Oh, a lot of that is in the law. For example, under the law, the so-called Dodd Amendment, no more than 1/3 of the total compensation package for any individual can be incentive-based bonus down the road.
Right.
Now that, to some, is counterintuitive. I mean, some might argue that there should be a much greater percentage of compensation tied to future performance. And doesn't that incentivize companies to give $10 zillion in salary? So a lot of this had to do with the law, especially that 1/3 limitation.
Okay.
But you're correct. The diminished salaries, the salarized stock, that was our discretion.
Okay. Now, on this question, again, if this question of level versus structure, and I'm thinking like an economist now, not a lawyer, because I am an economist by background. One thinks in terms of risk and return. One of the things you're doing here, and I'm sure most people would say it's admirable, it's right, is that you're asking these executives to actually take on more risk in their own compensation. You're asking them specifically to participate in the downside, which has been conspicuously absent from some of these contracts in the past. But as it were, the market response to that would be an increase in the level of their compensation. That is to say, if you're going to, if there's a market out there for executive pay, which there is, and you're going to ask these executives to expose themselves to the risk of doing very badly when their firms do badly, the market response is going to be that they will do even better when their firms do well. Conceivably, therefore, this regime that you're laying out will increase actual realized compensation in future years, although it might have these desirable properties. Now, quite obvious question, is that okay with you?
Yes. I mean, you're raising a series of questions. And I don't know. I mean, the glass is half empty, the glass is half full, depending on how you look at this. You say, for example, by giving corporate officials a vested interest over a 4-year period in the financial wherewithal of the company, that increases risk. Does it make it excessive risk? I mean, how much less excessive the risk than if you give people $5 million guaranteed and say to them, no matter what you do to the company, you're automatically going to get that money. So, I mean,
so it increases the executive's risk, not the shareholder's risk.
That's and query whether or not it's excessive. I think probably, I think not probably. I think strongly the way we've done this, I think tying executive pay to the long-term financial wherewithal of the company is a good thing. I think it's a good thing. I think that it's very important. You pointed this out. Do not underestimate the importance in our formula of this 4-year longer-term obligation before executives can redeem this stock. We think that the inability of the executives to immediately redeem the stock upon vesting is a very important part of this overall program. Short-term valleys, mountaintop and valleys in terms of corporate financial success and failure start to give way to a longer-term 4-year stability where hopefully there's more balance and stability in terms of the overall success of the company. I mean, somebody else may have a better idea, but that's what we concluded.
Right. Now, this is, I guess, an obvious question that you'll probably be reluctant to answer, but I'll try it anyway. The way you explain what you've done kind of gives a small role to the particular mistakes that these companies made and to the mess that they got us into. Because the indicators you're looking at, it seems to me what you're describing is a kind of best practice approach to the issue that ought to apply to any company and under any circumstances, not just if you're in the TARP and not just even within the TARP if you're receiving the extraordinary assistance. I mean, what do you make of the notion that what you've developed is a kind of template that should be more broadly applied beyond these special cases and to a much wider set of companies?
I would hope it would be more broadly applied privately. I don't think there's a role for the government to play.
Why not?
Because I believe, as the administration has said and as the Secretary of the Treasury has said, I believe that government does not want to get into the business of micromanaging executive compensation for widely divergent corporate America. And I think, hopefully you are correct, that the limited role played here by the government in the form of what I've done will be a model for others to emulate. Hopefully, the best practices that we have articulated will be voluntarily adopted in the marketplace. But as I have said publicly over and over again, I do not think, and I do not think Congress really has given any indication that it thinks, that this should this special master program should be broadened beyond these 7 companies. Now, having said that, it is true that under the law, as it now sits, being enforced, I do have this advisory authority, not mandatory authority, advisory authority to make recommendations, but even there it is recommendations to be made to those companies receiving TARP assistance. I have no authority, mandatory or discretionary, to go beyond that. So in terms of any pervasive, broader role to play here, I think my role is, as explained by you and others, very, very circumscribed.
Yes, of course I see that, and I don't suspect you for 1 minute of a power grab. That will probably be your worst nightmare, that you will be in charge of this process for a much wider set of companies having to do what you're doing. But my point is that the implications of your findings and the way that you explain what you've done do seem to kind of tear down the notion that the government shouldn't be in the business of micromanaging these decisions. That is what you're doing in these firms. You've explained the rationale for it very well. I can't see a very obvious reason why that argument wouldn't go through for a much broader set of companies.
Oh, of course you do. Of course you do. To talk about what I'm doing as somehow the government, for the first time, philosophically and ideologically intervening in the private marketplace, the government owns these 7 companies.
Sure.
The government here is acting as a creditor. Not in some philosophic sense that there's been a seminal change in the role of government vis-a-vis the private marketplace. Some of these companies are owned 80% by the U.S. taxpayer. The idea that as to these 7 companies who receive the most taxpayer assistance, the idea that as to these 7 companies, the taxpayer, as a creditor, doesn't have some interest in seeing to it how officials get paid, I think ignores the fact that we are a creditor. And there are very serious limitations going beyond the government as creditor to the government as somehow micromanaging a broader aspect of American business community.
I understand that perfectly. Well, I'm not for one moment arguing. Maybe I should just say this to be clear. I'm not for one moment arguing that what you're doing is in any sense illegitimate. Quite the opposite. I'm saying for just the reasons you say, and for the reasons you so persuasively lay out. There is a very strong case for doing this. But take the case of companies where the government is not a de facto owner. Surely your findings point to what an economist would describe as a kind of pervasive market failure, a pervasive breakdown of corporate governance. And in the interests of shareholders, the government has an interest in protecting the interests of shareholders, in making the financial system work more efficiently. Why doesn't that argument go through? Why can't you say, yes, this makes sense for all the reasons I've said for these companies that we, in effect, as taxpayers own. But what about all those other companies? We can't leave it to the management of these firms to make these decisions, because they will screw it up just as they did in the case of your 7.
You are making a very interesting brief to Congress. Congress has various bills pending. Congressman Frank, Senator Dodd. There are various bills pending under the rubric of regulatory reform, shareholder rights, corporate governance, etc. I have enough trouble with these 7 companies.
All right.
And making decisions as to these 7 companies. What you haven't mentioned yet is the fact that having issued my pay determinations as to these individuals, I now, in the next 2 months, must turn my attention to the next statutory mandated obligation that I have, which is, as you know, to establish pay structures, not individual compensation decisions, but compensation structures for these 7 companies for their employees numbers 26 to 100. Now, this is going to be a challenge because it's not determining compensation with a dollar sign for each of these individuals that I've done. Now I have to turn my attention under the law to outlining how these 7 companies should go about compensating their next group of officials. And that is a job that we now have undertaken, which is, in a sense, more precedential and more important than the first assignment of actually determining compensation for individuals.
And what is your deadline for that next stage? I'm wondering about, companies that get out from under TARP and then would presumably no longer be subject to that. So.
That's right.
Yeah.
Companies get out of TARP. For some reason, they're eager to get out of TARP. But
yes.
I think that the deadline is, December.
I see.
We want to get this done. And then we turn our attention, 2010. They're still under TARP. We start all over again in 2010 with establishing compensation for the top 25 for the 7 companies. Those will be different individuals. There'll be different issues.
Right. Just check the time here because I want to leave time for questions from the audience before we finish this session. But I'll just ask one more. The standard argument against the sort of broad approach that you're taking, that one hears again and again and again from the companies, the affected companies, and from others who perhaps fear that this, your initiative might lead in due course to a broader review of pay across finance and beyond, is that we have to compete in a global marketplace. This is all about retaining our talent. If you put this burden on us and other countries don't put the same restrictions on their banks, we will be at a sort of chronic disadvantage. And, in the end, the economy will pay the price. How do you respond to that?
I must say I'm very sympathetic to that argument. It's right in the law. The law says, talk about, avoiding vindictiveness. The law says one of the principles to guide me is that these companies be able to maintain and attract talent, that they be able to compete in the marketplace, that they thrive with the goal, the clear priority, repay the taxpayer the money due. So I find that argument about thriving and making sure that there isn't a punitive vindictiveness to this not only valid, but a priority in the law itself. And that's why I continually, if I'm asked, will argue that there is no vindictiveness and no punitiveness at all to what I've tried to do here with this program. And that is an argument that I hear quite often. The other argument I hear is sort of the flip side of that, which is what I'm doing is largely irrelevant. Won't make any difference. Nell can speak for herself in the panel after the break. That this is a well-intentioned effort. Limited as it is to 7 companies, it will virtually have no impact on the private marketplace. And that it won't be a model for others to emulate. And it is sort of fated to be a sideshow, to use the words of the Sunday editorial in the New York Times. I don't agree with that. I'd like to think that we will have a more persuasive impact in what we're doing. That remains to be seen.
Yeah, okay. If there are questions from the audience, I think we've got a little bit of time here. Dennis.
If you'd be willing to reflect a little bit, is this?
Yeah, it's on.
Can we hear? Okay. If you'd be willing to reflect a little bit of what you've just been through, which is the one creditor or one stakeholder, one owner has taken over from another owner of these companies in some sense. And they brought in a compensation expert to look at the compensation. And this compensation expert has come up with a radically different approach to compensation for these companies. What do you think that says about the dynamics of the the corporate governance in the sector as a whole, in terms of what's going on, in terms of the power balance between shareholders and managers. Is it possible to draw any broad conclusions about that? Is it too sui generis, firm to firm?
I don't think you'll like the answer I'm going to give you, because it's going to appear to be a dodge, but I don't mean to make it a dodge. I don't know the answer. There are other people in this audience who are more versed than me in discussing the overall implications of executive compensation across the spectrum, from financial institutions to automobile companies to manufacturers of zippers. I don't know. I know these 7 companies have been immersed in the executive compensation decision-making of these 7 companies. I'm not sure you can draw broad conclusions about corporate pay and make some generic representation. My experience is company to company to company, you have to examine what they do and how they do it. So I can only speak for these 7 companies as the special master, not any broader sort of overview here.
Well, fair point. So let me narrow the question then to what does it say about what you saw at those 7 companies and the implications for those
I think these 7 companies, as I said in my report, public report, what they submitted to me as what they proposed to do when it came to executive compensation in 2009 was against the public interest. It was contrary to the legal public interest standard. And what I did was modify those submissions rather substantially, both in terms of structure, especially in terms of structure, but also in terms of dollars, in an effort to vindicate the public interest standard found in the law.
I just follow up for 1 second, I'll take more questions. I'm just curious, and I meant to ask this before. When you began sort of tunneling into this information, you must know every last thing about the way these firms set these compensation standards. Was your reaction to think, well, that was probably a mistake. We can do this better, or we can improve that. Let's tweak this. Or was your reaction to think, my God, what were they thinking? Look at, they're just blind to these basic considerations. I'd just be curious to know what your sort of instinctive reaction was to this.
My instinctive reaction is a lawyer's reaction. Here's the law.
Okay.
The law is staring me in the face. Congress has laid out what it wants to accomplish. Here are the detailed Treasury regulations implementing the law. Here is the submission from the 7 companies. What are they thinking about? There's the law, there's the regulations, and my job is to modify those submissions to track the legal requirements spelled out by Congress. And that's what I think I tried to do.
Okay. Now, that's another dodge. But I have to keep reminding myself that we're in a law school here. Please.
In a sense, one could look at this situation as being the shareholders imposing reasonable constraints on compensation, something shareholders really have not done.
Right.
So my question to you is that all of this knowledge, all of these guidelines that you fashioned, would it be of value to propagate them to shareholders so that they might impose more reasonable restraints on their corporations instead of relying upon the government to do it or the government to bail them out if they don't do it?
You're asking a very important question, and that is, at essence, how do you meld what I've been trying to do with compensation decisions tied to numbers and the statute? How do you meld what I'm doing with the broader issue of corporate governance and the extent to which much of what I've done is at the end of the process. At the beginning of the process is structural reform concerning the role of shareholders, compensation committees, compensation consultants, etc. And to the extent that your question is directed at the recommendation that there be corporate governance reform, which may make shareholders more involved in compensation decisions and make some structural changes in the way that executive comp is determined, that is an aspect of this, which, as I understand it, as a layman, is being addressed now in whole or in part by Congress, by Congressman Frank and others. And in my 26 to 100, some of that may or may not be included in what I lay out as a compensation structure. So I think there's a lot of attention now being directed at the very question you posed concerning shareholder rights and shareholder roles in all of this. And it remains to be seen whether Congress primarily is going to pick up that mantle and do something about it.
Do you think it should, or is it above your pay grade to express a view on that?
It's above my pay grade to express a view on that, other than to say that under the law that I'm interpreting, we did make some reference to corporate governance in my report, which is available, and it remains to be seen how much beyond that reference we'll go in 26 to 100. That's a little unclear yet as we get ready to tackle 26 to 100.
Okay, another question. Is there anyone over? Please.
What do you see as the role of the board of directors, who are, I thought, representatives of shareholders?
Again, what is the role of the board of directors? Again, that goes, I think, I'm not trying to, really, I'm intrigued by this, but the whole question of corporate governance, shareholders, boards of directors, independent compensation committees, independent compensation consultants, if there is one. I think that those issues, all under the umbrella of corporate governance, when it comes to compensation, I think there are others looking at those issues right now in terms of trying to bring some reform to those areas. I think they all have an important role to play. I'm really not prepared to focus on that. I've got enough problems.
Sure. Any more questions? Sir, at the back. Yeah.
Section 111 of the EESA talks about limits on compensation, but the interim final rule from the Treasury seems to have kind of an interesting balance in talking about reviewing and improving compensation structures. So I'm curious how you have viewed that. There's been kind of some discussion about whether your authorization is to simply accept or reject, or rather whether you are in more of an area of setting structures. And I think the rule reflects that. I'm curious to hear your thoughts on that.
Spoken like a third-year law student who is an expert in administrative law. We have taken the view under those regulations that we shall determine compensation structures, but not without substantial input from the 7 companies themselves. We were reluctant to interpret the law and the regulations as merely imposing a czar-like power on the special master. And instead, we took the view that we would be much better off legally and politically, and in terms of fairness, in welcoming the 7 companies into an ongoing dialogue about the findings. And we have rendered our decisions last week with great input, intense input from the 7 companies. The law, as you know, allows them to appeal to me, an administrative law feature of the law. They can appeal, but only to me. If they feel that I've made an incorrect decision, I have not acted reasonably, and we'll see. No one's appealed yet. I'm hoping there will be no appeals, but they have that right as part of the balancing that we've tried to do.
Okay. I have another question. So,
I'm thinking about the
perhaps you just have... one moment, and we'll give you a microphone, and everyone can hear. Try that. Thanks.
I'm thinking about the end game here. When the TARP money is paid back, the question that I have is how much of the legislation, how much of the Treasury regs, how much of your report will still have influence on the way executive compensation occurs?
Now, this is a tough question. It's a tough question because the questioner is not only the former dean of the law school, not only the former chairman of the FTC, but my mentor from law school. So I am under tremendous pressure in answering this question from Professor Potofsky. Now, the simple answer, of course, is it remains to be seen whether, as soon as the government legally disappears from the picture, do these companies and other companies not beholden to TARP? Will they go back to the old way of doing things? Now, one answer is, as I understand it, some of these companies, by necessity, will be beholden to TARP and the taxpayer for many, many years. It's not like they can repay this money right away. So they remain subject to monitoring and this law. But I think it's fair to say that other companies that right now are part of the 7 that are my jurisdiction are trying to figure out how quickly they can get out from under the thumb of the federal government. As others got out from under the thumb of the federal government just as soon as they possibly could. And I think, if I understand the law correctly, in order to get out from under the thumb, they need the permission of the Federal Reserve and or Treasury to pay back the money, even if they want to pay it back. So I remain ambivalent as to the long-term or short-term impact of what I'm doing. There are many people who have asserted publicly that what I'm doing is a nice, well-intentioned, noble effort that will have no real ripples beyond the immediate decision. I am not a soothsayer or I can look into a crystal ball. It's pretty murky. I don't know the extent to which my decisions will have some long-term impact. I think that the most likely area where I'll have a long-term impact is, frankly, 26 to 100. The compensation structures that I have to come up with that will be sort of a blueprint that these companies have to follow in setting their own compensation for their other employees. Maybe there other companies and regulators will pick up on what I'm doing. And that's the other point. Quite apart from what I'm doing, there's been an expression of interest by the other regulators. The Federal Reserve has promulgated some guidelines and has expressed some interest in broader regulation of banking institutions when it comes to executive comp under their jurisdiction. The SEC has expressed some real interest in transparency and shareholder rights and other areas of corporate governance. Maybe between the SEC, the Federal Reserve, Maine Treasury, my office, maybe all together the regulators will come up with something that will be more than just what I'm doing, and there might be a broader effort to regulate executive comp. The other final hope, and again, the panel afterward will focus on this, the other final hope is that private corporate America will see that's what's coming out of the special master's recommendations, the Federal Reserve, the SEC. Maybe there'll be some private, voluntary effort to restructure and better regulate privately corporate pay. We'll have to see.
I've got a follow-up question. I might just sneak in here. one of the things that we talked about earlier was the argument that you're getting from a lot of finance people that this is a dangerous approach because of the global competition aspects. One of the things that strikes me about what you said today and what I've read you say in other interviews is that your effort is actually really quite siloed. I mean, you're focusing on these 7 companies strictly under the terms of the law. Meanwhile, the Federal Reserve is proposing a very, it seems to me, dramatic initiative in terms of introducing executive comp into their financial regulatory thinking. And similar things are going on in other countries. Now, am I right to think that you haven't had negotiations or discussions on the substance of what you're doing with the guys at the Fed who are doing what they're doing, or with other governments? And if not, isn't that a pity? I mean, shouldn't there be an attempt to better coordinate these regimes precisely to meet this objection on global competitiveness grounds?
It would be a pity if it were true. The fact of the matter is we have been in consultation with the Fed and with the SEC. And the Secretary of the Treasury made it very clear that this was a subject of discussion with the G20 and others. So I think there is a fair degree of interaction. My report spells out that in at least when it comes to at least one company, the report spells out that I relied quite heavily on the views of the Fed and the Department of the Treasury concerning global competitiveness. So I think it would be a pity and it would be a mistake if I didn't take advantage of that interaction to coordinate with these other regulators, yes.
But you feel it's enough? I mean, it seems to me that this is a weakness of the approach going forward. You know, that the G20 governments did commit to talk to each other about these issues. I mean, my own perception, I think it's quite widely shared, is that process is slow, and there hasn't been very close coordination, and different countries, even within the European Union, are approaching this issue in very different ways.
I mean, I understand the diversification and the slowness of the arguments and all of that. What I find so interesting about my work is that it is important to announce and promote generic prescriptions about pay.
Right.
I do think there is a value in that. I think what the Federal Reserve did the other day is important and to be encouraged. As part of my effort, we've been in touch with the Federal Reserve. I had to go one step further. I had to take the prescriptions in the law and calculate dollars. And one reason I think there's such interest in what I've done is just that. It's not simply we think that compensation should be performance-based. We think that compensation should promote international competitiveness. We think that. We think this. All right. Under the law, take those prescriptions and put dollars next to names. That's not easy to do. That's not easy to do. I'm not sure that I will ever be able to satisfy everybody. I'm not sure I'll ever be able to bridge the gap, which is huge, between Wall Street mentality and Main Street mentality. That's a historical problem. I think that's always been a historical problem in this country. Trying to deal with that gap is a formidable political, in the best sense of the word, political undertaking.
Okay. Other questions? Yes.
I wanted to ask, what is your methodology for this second tier that you're about to address? You said that may be the most important work you do, but we haven't heard how you plan to do it.
Well, it's a very good question. How do I plan to develop a similar type methodology for 26 to 100? One, we've received all of the submissions from the 7 companies as to the areas that they think the principles, because I don't have to calculate individual compensation. There'll be no dollars in 26 to 100. But they've submitted proposals with the principles that they think should govern. We have my 1 to 25 methodology, which certainly, as Clive's pointed out in the last hour, lays out certain principles: less cash, more salarized stock, longer-term redeemability periods, repay TARP, etc. How much beyond that we'll go in fashioning a blueprint that is focused, for example, on General Motors rather than Citigroup for the parochial problems confronting GM and the auto industry, that remains to be seen. But I think the jumping off point will be take a look at the principles that governed in 1 to 25. How should we modify those or add to those principles in dealing with employees 26 to 100? And you have some skeleton, at least, of the direction we will go.
Okay. I think maybe we have time for another question or two. Yes.
In the past, the pay for performance has...
Maybe you could, you're right by the mic. Maybe you wouldn't mind just standing at the mic.
Sure.
Thanks very much.
In the past, the pay for performance has to some extent been attempted, and so you've had performance artificially sort of inflated to then equivalently raise the pay. So do you think there's someone, or there's a need for someone in your capacity to take a systemic view of the regulatory, whether it be corporate governance or governmental evaluation of the performance aspect that's kind of been driven by the need for higher pay?
Yes. And I'll tell you exactly who you ought to ask that question to. Congressman Bonnie Frank and the Congress. Because what they are doing right now is trying to answer your question, which is, it's been raised before. It's the same answer. To what extent, Special Master, are you engaged in a process which is the tail end of the real concern over how you structure pay? And shouldn't you be looking at corporate governance, to wit, shareholder rights, the role of compensation committees, the role of the CEO and the CFO vis-a-vis the compensation committee and the shareholders, say to pay, other initiatives that are out there? My understanding is, although I'm involved sort of at the tail end of the process, those questions are at the head of what Bonnie Frank and Chris Dodd and others are looking at right now. That's right now what they're looking at. They're mocking up a bill right now, which I think has many of those corporate governance features.
And similarly, there seems to have been also a failure in governmental regulatory enforcement of a lot of the factors that led to this sort of crisis. So is there that component as well?
Yes, to the extent that you're asking me, has there been a failure in the regulatory apparatus? That's not on my watch. And that is precisely, I mean, you're raising very good questions where the Congress, I think, and the administration are taking a look at all of that, not me.
Okay. You might have time for one more question. If there is one more question, yes, please, sir.
You've talked a bit about how you hope that this is kind of adopted as best practice, or that the work you've done can be extrapolated to entire industries. But you're representing the government as a creditor, hopefully a short-term creditor, trying to maximize public interest. How far can shareholders adopt this as shareholders trying to maximize the long-term value to themselves, the profit of the company?
That's a question that you should direct at Nell after the break. Nell has stated publicly that I'm a good guy, but what I'm doing doesn't matter very much. So
I didn't hear her say you were a good guy.
That's right. Nell will speak for herself. But I think, again, that to the extent that there are questions posed about the role of shareholders in all of this, very, very legitimate. I mean, seminal questions, maybe the most important questions. To the extent that there's a question about shareholders, there's a question about the appropriate role of the private corporate mentality when it comes to compensation. All I can say, it's very unsatisfactory in responding to your question, all I can say is I'm doing what the law requires me to do. How much impact I will have over what period of time, how pervasive that impact will be in shaking up shareholders or bringing private marketplace reforms to the subject of comp, I do not know the answer to that. I will continue to do what I'm supposed to do and hope, I do hope, that there will be some broader impact beyond these 7 companies. That remains to be seen.
Okay, thank you. I think we've
Go ahead. I'm sorry, you had a follow-up?
I'm sorry, you have a follow-up.
Would you argue, though, that in representing the government as a creditor and maximizing public interest, that if shareholders were fully empowered to have as much say as they wanted over executive pay, that they would want to adopt your same framework? Because your goals seem to be different.
I have no idea. I have no idea how whether shareholders would want to adopt some of these structures. I suggest that probably shareholders is too generic a term. There may be some industries or some companies already that could say, we already did what you're doing. Other companies, I don't know, other shareholders. My only advice, I think, based on my working with these 7 companies, is rarely does one size fit all. And even in it's right in my report. Take Chrysler Financial. In my report, I point out that there is no stock that's available to the officials at Chrysler Financial. That company's in wind down. There is no stock. So there's an example where the stock, the salarized stock, and the long-term incentive-based stock, it just doesn't work institutionally. That company isn't equipped to accept the notion of stock going forward for 4 years. In 4 years, they're not going to be around anymore. So one size doesn't fit all, and I suggest that when it comes to shareholder rights or shareholder empowerment, probably it's a more micro approach, but maybe not. That's just my sense of it working with these 7 companies.
Okay. Well, listen, we're going to come back to these issues after the break. We are going to stop now, take a break. Meryl's going to come up and I think and say a few words. But while you're coming up onto the stage, please join me in thanking Ken for this conversation.
Very much, ladies and gentlemen. We're going to take a very short 10-minute break, and we'll resume with our panel. We thank you all for coming today. Thanks a lot.
Thank you. I thought that was fascinating. I thought it was great. No, you were.
Thank you. But the rubbish.
He was very helpful to me. We've done some research. So the question very helpful to me when I handled the compensation package for the families of the Columbia Aspen.
You can either be smarter than this or he might be wrong. I see 3 possibilities. He's more powerful, he's smarter, or maybe he's wrong. Maybe the existing incentive structure. And that may be, I guess my point is, for all of my personal that may be a rational, maximizing approach for shareholders. It might be. I don't think it is.
Yes, they are.
Gives me time to run up to my office.
But then they need to find structures that are and it's system structures. Well, presumably what Nell's trying to do. And it made some progress. Dennis Whittle. I was at the World Bank for a long time, doing similar things. Now I've got my own private organization, friend of Clive Crooks, who advised me today. So, what about yourself? What an extraordinary character in all dimensions of that adjective.
Hey, it's good to see you. Yes, it's been a long time. I'm here. This is Bob Thompson.
He is one of the most focused.
The old right-hander. Yeah, well, we spent many years on big golf.
Pick that up. Hey, Ken. Some talent.
Well, that's
That's a long time.
That is a supposed to have even been crazy.
Try again.
Now, what are you
Well, I wouldn't think her hospital.
Yeah. I'm in LA.
They don't know I'm here.
How are you? Are you going to be able to stay for lunch? Good to see you. Well, I enjoyed this. I have these very This is my well, I can see very interesting. He's at one speaker. He's so good at articulating it's a collaboration. It's a collaboration. It's sort of what we're doing to finish out San Francisco projects with some of these, and there's going to be an honorable programs here, but that are sort of Aspen Institute spearheaded. Okay. Oh, thank you so much. You know how to do that?
We listen, we don't.
Thank you so much. See you soon. I'm sure I'm going to see you at some yeah.
Do you have my call?
No. Let me give you mine. No, not today. Not today. No.
But you
yes, I haven't practiced in many years. No, academic. Well, academic. This for a number of hobbies, but then came to Washington. So I moved into the academic world. I teach here at Georgetown Law. I run oh, yes, here in Washington, University of Olson. Sure. Yeah, of course. Yeah, that's right. I know. You come to the book club.
Exactly.
Are you going to hear Paul Gold, an architect?
It's going to be
I think it's a 10.
I will be back.
Yes. I talk about architecture. I find it.
And you will be there.
I will listen
that I did not.
I did.
Okay.
He will be.
Have the pleasure of always to come and learn.
Yeah, well, what?
It'd be great to get together for lunch. Well, if you bring some time, I live in Spring Park.
Wonderful. Great to see you, Mel. Nice to meet you.
Ladies and gentlemen, if you can, if our panel will assume their seats. Thank you very much. We're back.
You tend to lose the members.
Okay. Just one brief housekeeping announcement. We are going to have a buffet lunch following the panel at noon in Gewertz 12, and you are all welcome to attend, so please join us. Well, we're back, and I'm going to turn this over to Clive Crook to introduce our panelists to talk about the subject of corporate governance, and in light of Mr. Feinberg's very interesting comments. And Clive?
Okay. Meryl, before you go, just remind me, when do we have to wrap this up? What's our timing?
12.
Quarter to 12?
Quarter to 12.
And then we have some Q&A, or Q&A before?
Including the
Q&A. All right.
Yes, we're out of here at quarter.
Sorry that I had to ask, but I thought I'd just be clear about that. Just a very quick word of introduction for members of the panel. Nell Minow is the co-founder and the head of the Corporate Library, which is a group that I guess I would call you an activist group on corporate governance issues. I regard Nell as maybe the leading commentator in the country on corporate governance issues. It's a real pleasure to be on a panel with you again. Chris Brummer is a professor here at Georgetown Law. John Olson is a lawyer and a distinguished visitor at Georgetown Law. And Mike Oxley really needs no introduction, former U.S. Congressman, former chairman of the House Financial Services Committee, and an eminence on the matters we'll be discussing.
And a lawyer.
And a lawyer, of course. What I thought we'd do is I just ask each member of the panel to begin with to say a few words in response to the conversation we've just listened to. What do they make of what they heard from Ken Feinberg? And then we'll take it from there. So, Nell, maybe you'd like to kick off.
Yeah, I would definitely like to kick off because I want to correct the record in terms of his characterization of my views. Yes, indeed, I do think he's a nice guy, so he was right about that. But he was wrong in saying that I don't think that his work will be meaningful. I think it is meaningful. I guess the best way for me to describe it would be necessary but not sufficient. I think that he did a better job for the taxpayers than he did for the shareholders, but that's, again, his job. I think that he certainly will keep people focused on paying back TARP. But as he reminded us in virtually every answer he gave, he was very, very limited in scope and duration and quite literally in options. For example, the statute prohibits his use of stock options as one element of a compensation package. And so to that extent, I don't think that it will be a template for others to follow. On the other hand, I do think that it changes the conversation in a useful way. Ultimately, however, we're not going to address the systemic problem of excessive CEO pay, excessive meaning out of sync with performance, and promoting the wrong kinds of risks, until we address the corporate governance issues that were raised by so many of the questions. And that's what I really want to get into here, because I'm vitally interested in what boards do, what shareholders do, the role of state law and federal law, the SEC, and I think that's where we need to turn next.
Okay. Chris?
I found the comments also very interesting. My area of expertise is really international finance, and I've been at least observing casually different moves, not only from the G20, but these new international organizations that many of us are just now learning about, like the Financial Stability Board, both with regards to the promulgation of principles regarding executive compensation, and then the implementation by different member countries, including the regulators like the SEC and like the Federal Reserve Board here. I think the implications, the broader implications, not only nationally but also globally, for what is occurring in the executive compensation space will be quite significant. And I think that the work that the Special Master Feinberg is doing will likely complement global efforts. And when you look very closely at what Feinberg is currently doing, you see lots of similarities with international approaches and principles that are, in some regards, a bit more prescriptive even than he seems to suggest.
Okay. You go next.
Me?
Yeah.
Okay. I, like everyone else, compliment Ken Feinberg on his work. I think he had a tough assignment. He was prescribed as what he could do by a statute. But I also would agree that what he's done for what I call the Seven Sad Sisters is not going to necessarily be the formula for everyone else. And I think Nell and I, we agree on much more than you might think. I've had a real interest working with the Aspen Institute over the last several years on the problem of short-term thinking as it affects not only management decision-making, but investor decision-making and government decision-making. And it's interesting to me that Ken Feinberg's view of long-term thinking or longer-term thinking is a time horizon of 3 to 4 years. For most investors, that's a pretty short time horizon. That fits, as Nell says, repayment of TARP funds and maybe recovery of some of the equity that we've invested in a company like AIG, where, if I remember correctly, we own as taxpayers something like 80% of the equity. But it isn't really long-term in the sense of business planning, of new products, of international competition, of the investor goals of pension funds, particularly index funds, which are looking at time horizons from wherever we are now in our lives to when we retire and need to fund that retirement. So I think this is interesting. Some of the concepts are important, but I don't think it addresses the major problems. I'm also a little skeptical, and I heard some questions from the audience about whether shareholder involvement, and now and I may differ, is going to be the panacea people think it is. There's some very interesting research that Bill Bratton, who's on the faculty of this law school, has just completed in a draft paper that's been posted on various sites, and it's going to be published, I think, in Penn Law Review fairly soon, in which he suggests that if you look at the history of shareholder direct involvement in the context of the last 20 years or so, where shareholders have been more directly involved, the companies have actually pursued shorter-term goals and immediate gratification as opposed to longer-term goals. There's some competing research done by some people at Harvard, including Lucian Bebchuk and some of his colleagues, which points in the other direction. I don't have a view. I'm agnostic on who's right, but I think these are very real and difficult issues, and I think we're just beginning to scratch the surface, both in terms of government and regulatory policy and in terms of what to do with respect to management decisions and investor decisions to deal with these issues.
Okay, thank you. Mike.
Well, first I want to thank Ken Feinberg for replacing Paul Sarbanes and I as the ultimate enemy of the C-suite. He's managed to accomplish that in a very short time, and we appreciate it after 7 years of being in that position. I was also particularly impressed with what I would call somewhat judicial restraint on his part, not rising to the bait to some of the questions, and his responses were quite reserved and truly in the context of his job and how he sees it based on what the law is. And he kept coming back to that, and I truly appreciate that, because I think, as I told him afterwards when he congratulated me and Senator Sarbanes on our act, that in many ways his, and here I disagree with Nell, I think his decisions and his report will have long-term implications that people, frankly, don't see right now because we're so involved in the now. But in the future, I think we're going to see that, and we will see that, in my estimation, in boards of directors, particularly compensation committees, taking on some of these issues. The public pressure will continue. I remember hearing a lot of complaints when Say on Pay passed the House twice, a bill that my successor, Barney Frank, introduced, and remarking at the time that if the corporate sector only gets Say on Pay, they should get down on their knees and thank God if that's all they have is a after-the-fact vote that's non-binding on corporate compensation and on say on pay. And I think that prediction is starting to come true because obviously there's a lot more out there that's going to happen, and it's a healthy debate. And this forum is part of that healthy debate, and I look forward to the participation. Thanks, Clive.
Okay, thank you very much. Let me put a question right back to you, Mike, if I may. When you look at the issues that Ken Feinberg was discussing, which is a really kind of narrow set of companies he's looking at, these seven firms, you don't think, from what you've just said, I'm thinking that you don't believe that the debate's going to stop there, and indeed that legislative action is going to follow that will go more broadly than the companies that are deeply implicated in the financial crisis?
I'm not necessarily predicting that. What I am saying is that the debate has been elevated substantially from the say on pay, the public perception, which is critically important in anything, whether it's a regulatory nature or a legislative nature. Obviously, we have a democracy, and constituents are also shareholders, and they respond to these kinds of things that they see on television, read in the newspapers. Enron, WorldCom, and the outrage that we saw in the public, in many ways, probably was more acute than now, and I'm still kind of trying to wrestle with why that is the case, and I don't really have a good answer for it. But clearly, public opinion has a major impact on what's going to happen. As Ken pointed out, the Congress, literally, the Financial Service Committee is marking up legislation. Has the last 2 weeks, and this week another one, on those very issues.
Well, the House has already passed a say-on-pay bill, but the Senate,
and the Senate's never passed it, and
it hasn't moved in the Senate yet.
Yeah, and I think that
again,
I think that that's true, and they've shown
no interest. Who was the sponsor
in
the Senate of that legislation? Do we remember? It was the junior senator from Illinois, who's now the president.
Yeah.
So I think there is a lot of support.
Has it even been introduced in the Senate now?
Whatever happened to him, anyway?
Let me ask this. I mean, how far do you guys think that a corporate governance is actually at the center of this issue? I think I know what Nell's going to say about that. But there is a rival theory. I mean, one theory of the case is that this sector was badly regulated in a number of ways that don't actually bear on the corporate governance issue.
Which sector are we talking about?
Finance.
Well, because we often
finance and banks
and automobiles.
I'm sorry?
And automobiles?
Yeah, well, let's put the car companies to one side just for the moment. Let's concentrate on finance, which is really what got us into this mess.
Well,
one view, let me just state the case and then get you to respond to this. In thinking about the way regulations should change going forward, one view is that and I think this may be my view, that the crucial reform is to increase the capital requirements that banks and non-banks have to provide. That these entities were taking risks as they perceived at the time in their shareholders' interests, in their owners' interests, and it was the population at large that ended up having to pick up the bill for that. There was an implicit subsidy to this sector through the too big to fail doctrine, and we found out that firms that we had previously thought were not too big to fail were too big to fail. Now you fix that by making these entities set aside large amounts of capital. And then this argument would go, you can carry on letting them set pay as they see fit. In other words, this is not a corporate governance issue at all. It's a financial regulation issue.
Can I just say that even there, when you look at what kind of capital charge a bank should take, different approaches would involve, for example, setting your capital adequacy requirement in light of the compensation practices of a particular financial institution. So the degree to which that financial institution engages in particularly risky compensation would then, under certain kinds of reforms being contemplated even now with regards to Basel II,
these things
comprise a kind of capital charge. So the question is whether or not corporate governance can be so easily disentangled even from capital adequacy.
But that's really what I'm asking. Is corporate governance the heart of this thing or not?
Sure it is.
You think it is?
Chris is entirely right. And since we're in a law school, I'm going to say a law school thing, which is that it's a seamless web. Everything is connected with everything else. And if the pay, pay is the ultimate symptom of corporate governance, whether it's working or not. If the pay is well designed, then no matter what the capital requirements are, the executives are not going to take unnecessary or inappropriate risks because they won't be able to externalize those risks onto the taxpayers and the shareholders. And furthermore, I think it's really important to mention, sure, there's only one thing we want from Wall Street, only one thing. We want them to be able to do math. That's all we ask. We don't expect them to be ethical, moral, set public policy. We just want them to be able to do math. And if they cannot figure out, despite what the capital requirements are, what is appropriate for them, then they're not. Then it's because we're not incentivizing them correctly. And I think, furthermore, that the reason that the capital requirements were reduced to an insane number is that a lot of money was pouring into Washington from these very same people. Again, externalizing the cost of misappropriating shareholder money to get rid of a lot of these regulations. And over $600 million was spent by the financial services industry to get rid of legislation like Glass-Steagall, to change the capital requirements. And again, if their net worth was at risk, they would not have appropriated the corporate funds that way.
Okay, John, you want to?
Just a couple of thoughts on that. I'm all in favor of good governance and sensible compensation and trying to have compensation properly.
No butt coming on.
Let me express a little skepticism. I think it's a seamless web, and I agree with that, but I think there are limitations on what one can do with pay. We talk about wanting to have executives have a substantial long-term equity stake in the enterprise, and that will cause them to do the right thing. Well, look, Dick Fuld at Lehman had almost all of his personal wealth in Lehman stock. He didn't sell any. Jimmy Kane at Bayer, the same thing. Nobody would say that those people properly assessed risk in retrospect. They went down with the ship and went down big time to the tune of billions of dollars. So compensation in and of itself is not the panacea. I said that earlier. Perhaps you can argue that those boards should have been more alert to who was leading the company, what the strategy was. Certainly the regulators should have been more alert to capital requirements.
Look at the Lehman board for a minute. They had an actor, they had a producer.
Let me finish.
Then you'll get
and the companies that are thought generally to have gotten it right and sailed through pretty well are Goldman Sachs and J.P. Morgan Chase. Nobody would say that during the time of the run-up that either Lloyd Blankfein or Jamie Dimon was undercompensated or didn't get lots and lots of reward on an annual basis. Why are those companies different? Well, there have been some studies done. And one of the studies says it has something to do with the quality of the culture. It has something to do with the experience and relatively short length of service turnover in the board, which goes to other corporate governance issues. Compensation doesn't really seem to have been a major driver in who succeeded and who failed. Interesting final point. A recent survey was done by an investor group of investors on a telephone poll basis, and they asked investors what they thought were the most important factors in the financial collapse. Boards of directors and corporate governance was thought to be most important by something like 4% of investors. Regulatory policy and the sort of boom that we all fed with our belief that we could live on credit was thought to be the major factor. I think that's about right. I think investors, when you ask them in mass, not the professional advocates, but investors in general, would say, yes, corporate governance is important. Yes, we want good boards. Yes, we want sensible compensation. But we were on a national binge, which was aided, abetted, and encouraged by the Congress and several administrations of both parties. That was the major cause. It wasn't because somebody paid too much to some executive here or there.
Now.
Well, again, let's look at the Lehman board. They had a producer, they had an actor, they had a former admiral. They didn't have a single person who understood anything about derivatives. And if you really were on the line, I think that you would have made sure that they had a better board. Or if investors had been able to make sure they had a better board, I don't think all this would happen. Listen, there's not going to be perfect. It's not going to be perfect. There's always going to be failures. And Americans believe in taking risks, and we believe in fairness. I think the reason that people are furious right now is not that people in Wall Street made a mistake and need to be bailed out. It's sort of like Katrina. We're happy to go in there and build houses when disaster strikes. It's when they mistreat us by having huge bonuses while the rest of America is suffering. that seems fundamentally unfair to us. Now, with regard to a telephone survey of investors, I don't know if they were talking to people who have 401ks or if they were talking to major institutional investors who hold 70% of the stock in this country, but the people I deal with are the major institutional investors, and they're pretty confident that it is the boards and the executives that are at fault.
Well, and the major institutional investors, at least in person of CalPERS, could start attending to their own house in terms of governance.
That's
true, isn't it?
I mean, on that, and I would be happy to discuss
you're absolutely right. 70% of the money in this country is managed by intermediaries, and one of the questions that is not being addressed by the Congress, but is increasingly being addressed in the press, is who's in charge of the intermediaries and how are they governed?
It's the same bailout companies. That's exactly. You know, you're asking. It's not even having the fox guard the chicken house. You're asking the chickens to guard themselves. You've got, Merrill Lynch and Goldman and all that. They are the big, and Citigroup, which repeatedly voted its shares and the money that was managing for other people on behalf of portfolio companies who happen to be clients or wanted to be clients. I mean, John Bogle is all over this subject. So, yeah, of course, that's a huge problem, and we can talk about, some possible solutions there, including independent voting fiduciaries.
But the point I was trying to make at the beginning, I would be interested, Nell, to hear you respond to this, is that, I think, and I don't think John is disagreeing, there is a corporate governance issue here. The question is, how important was it? And I hear you kind of saying that it was the critical thing. The problem in the financial system as a whole was surely the risk that the taxpayer was going to bear when these companies took outlandish risks and ended up failing. But the shareholders are on the other side of that problem. They're with the managers on the other side of that problem. Their interests in this respect diverge from the interests of taxpayers.
Yeah,
right?
They love the increasing stock prices. And so it brings you to the Paul Volcker, Mervyn King approach, which is, maybe we got some real structural problems. Maybe we need to reinstate Glass-Steagall. Maybe we should not have the moral hazard created by allowing institutions to be so big and so dependent on the government that they, in fact, can't be allowed to fail.
I
agree with
that. I wonder if you look at your question, not from sort of this ex ante, but instead from an ex post perspective, from where we are right now. I found Ken Feinberg's response fascinating, this response that I don't really expect my work to necessarily have repercussions outside of these 7 companies. The government really has a little role to play. In response to John's comments just now, I wonder, particularly since institutions, large financial institutions, have now an explicit guarantee by the government. Right. Even though the government is no longer a creditor, by having this explicit guarantee, it is now a financer of these companies. What does this imply for the role of the government, if not in corporate governance, but in firm governance, particularly governance of systemically important financial institutions? There was a certain tension, if one will, in Ken Feinberg's response that on the one hand, he is acting on behalf of the creditors. He is operating under a very precise legislative mandate to set executive compensation standards on the one hand, but then as the conversation evolved, you have terms like the SEC and the Fed and Treasury departments thrown in, even now G20.
Right.
And that seems to imply that you may not be able to necessarily abstract generally to all firms of all different sizes, let's say industrial firms, but now getting to your initial focus on financial institutions, it seems to at least mean that there's been a movement in the conversation, no matter the political stripes, where there is at least an acknowledgement that large financial firms have a special place in the international and global economy. And given this particular place, something needs to be done to regulate them. We've already established that corporate governance can't necessarily be easily disentangled. But you have questions then, what should the government necessarily do?
Right.
And simply asking, well, should the shareholders have more say on pay? Well, certainly other countries have tried this.
as early as 2003, I think, in the UK. It's meandered into other jurisdictions. We have different attempts here in the United States. The UK certainly continues to have certain kinds of problems. We've tried different kinds of corporate governance reforms after Enron, after WorldCom, right? We've established executive compensation committees, and yet the implication of today's conversation is, the implication is these brand new, shiny compensation committees that have been mandated by matter of law are apparently not taking in empirical information as to the pay of CEOs across an industry. That's at least the implied statement, right? So the question is then, well, do you need monitors for the monitors who are doing the monitoring, right? If, are shareholders themselves adequate monitors? Are even the institutional actors like CalPERS really the best monitors? Or do we end up where the government then is, again, forced to intervene because nobody else can, quite frankly, get their act together, right? Right. And so there's a certain kind of movement in conversations that I'm sure all of you have seen in all of our panels, because it really depends on where you start the conversation, right? And I would be very fascinated, given the expertise on this panel, just to get the insights of all of you as to, well, given the fact that even when we reform the corporate structure of the firms, we still have problems. Even when governmental intervention is probably not a panacea in and of itself, and obviously shareholders can improve monitoring, but we've seen problems there as well. Is this even a problem that can be fixed, or is it just a question of mitigating risk by just a high capital charge?
Well, that's a good question. Mike, what's your view on that?
First of all, if you start a conversation, is it true, is it accepted that we essentially have a 21st century economy with an early 20th century model for regulation? I mean, I don't think anybody argues differently. And what the Congress is going through now is akin to what went on after the Great Depression or during the Great Depression, when the basic structure of regulation was set up, and we've lived under that for 80, 90 years. What's going on right now, for better or for worse, will essentially set the standard for the 21st century. It is almost inevitable that you have to deal with that issue, that underlying issue of how much regulation, what kind of regulation do you want a single regulator? There are all kinds of, do you want to merge the SEC and the CFTC? All these kinds of nitty-gritty kind of issues are going to be decided reasonably soon, probably within the next 18 months. And we will be living with that for a long time. And so I think I give the Congress a lot of credit. They are working assiduously but not hastily on trying to do this with the idea that they need to get it right because it's going to be around for a long time. So that's, if you want to start a conversation on that, that is a great place to start. And then you can argue about how you want to make that infrastructure of regulation.
Can I ask you a question about that, Mike? The Congress has established a bipartisan commission, which is just getting started, which is due to report about a little over a year from now as to the causes of the crisis, and although they don't have a specific charter, as I understand it, to prescribe remedies, I think they intend to do that. Is that going to have any impact? Will Congress wait until that report comes in, or will they move ahead without waiting?
You know, that's a good question, John. I mean, I'm hoping it's not a ready, fire, aim kind of approach, because it really, I think, what would be the use of putting this thing together unless we could learn something from it? And given where the Senate is right now, that may very well be the case, that we could end up with the report coming out first and then the reaction. But I think it will be driven by public opinion, the pace of it, and the overall makeup of it, and I think that's difficult to predict. Again, I'm somewhat puzzled by the public's response to this recent fiasco, meltdown, whatever you want to call it. maybe it's because, and I've thought about that, maybe it's because back 7, 8 years ago we had some real villains that people could put a face with, you know, and Bernie Ebbers and
handcuffs.
Fastow and all these folks and doing the perp walk and all that. You didn't have that this time around. There were just a lot of smart people making some really incredibly dumb decisions based on bad information. But there was very little illegal activity, it seems to me, in that realm. And so to some extent the public maybe be confused, and it's a complicated subject. And I think that is what is kind of made the public reaction a little less shrill than maybe we would have anticipated, although the polls would indicate that people are very upset. But you don't have the folks charging the castle with pitchforks like you had in 2001, 2002. And to that extent it's different, and it may very well be that it will allow the Congress perhaps to wait until that report comes out. But it's really difficult to predict right now.
I want to respond to Chris's point by saying something that is really heretical in a law school and with a congressman present, but it's just true, and that is that, I'm sorry, it's just true. There are limits to structural solutions. And you know that if you're in law school, they spend the first year teaching you all the structures and the second 2 years teaching you how to subvert them. And so I got to say that you can enact all the Sarbanes-Oxleys in the world and all the 33 Acts and all the 34 Acts. You're never going to have as much energy on that side of the table as you will on the side that is trying to figure out how to get around it. As you see, we look at 162M and everybody just shakes their heads. That was the last time Congress tried to get involved in excessive CEO compensation, and it really poured gasoline on the fire. So I think at the end of the day, you really, you're always going to have this sort of daisy chain where any weak link is going to be a problem, and where there's always agency costs, there's always questions about oversight, and it always comes down to individuals. And that's one reason that in my company we rate boards of directors like bonds, A through F, and we're working on individual directors now. But ultimately, you just have to say to yourself, who has the best access to information and who has the fewest conflicts of interest, and try to keep that person in charge as much as possible. And that's why I don't want the government setting pay, and I don't want the shareholders really setting pay. Say on pay, you're asking them to have a binary, non-binding vote on a very complex matter. I don't think
on a
that's
20-page report.
Yeah, I don't think that's very useful. And again, corporations are very good at putting the pill in the applesauce and saying, here's 80% really good stuff in the pay plan, and we're going to also do this other stuff. Very hard to do. I think the only thing you can do is you've got to have some sort of change in the way that we elect directors. Right now, as they often say, director elections are more like North Korea than they are like anything that we would call an election. Management nominates the candidates. Nobody runs against them. Management counts the votes. We currently have over 90 directors serving on public companies who didn't get majority support of the shareholders. A majority of the shareholders said, throw the bums out. They are still serving. We currently have most of the directors of the TARP companies, the bailout companies, continuing to serve. Not one newspaper article, I'm looking at you, Atlantic, not one commenting on the bonuses at AIG put the names of the members of the compensation committee in the article. Is there any other field of journalism where we would leave out the who in the article?
I was actually struck on that very point when AIG brought in its latest CEO, and the government, including I think Mr. Feinberg, if I'm not mistaken, had to approve his compensation. Mm-hmm. He got a very, very good deal that seems to me quite out of character with what was imposed on the people already there and what was imposed on the other 6 of the 7 sad sisters. It seemed like $15 million guaranteed without. And I hope he's just a superstar and he's going to do a wonderful job. But
that's modest compensation, of course, by the standards of the industry.
Okay, but
by the standards of Goldman Sachs, yes.
As Damon Runyon said, the race may not always be to the swift, but that's the way to bet. And I think that anybody, I go back to the last government bailout, the then unthinkable $1.5 billion loan guarantee for, who was that again? Oh, yeah, Chrysler. And Lee Iacocca took $1 a year and escalated stock options. So he really had to perform in order for those to be worth anything. He immediately got the trust of the taxpayers, the customers, the employees, the community, and he made a boatload of money. So what's wrong with that?
Nothing.
What's wrong with asking these people
And that's essentially
until they succeed before we pay them?
That's essentially the deal that Ben Marsh's predecessor had, and then they fired him. But the government had brought in some.
He did a terrible job.
Well, so he was incentivized properly, but he just didn't do a good job.
I wouldn't even argue that he was incentivized properly. That's he was.
I think it proves my point that pay alone is not enough to assure good
again,
governance.
That's the way to bet, though.
Yeah. Well,
if the incentives are perverse, if you're going to pay journalists by the word, they're going to put a lot more adjectives in their stories. It's just a fact.
Most of them are paid by the word anyway, but there you go.
No, and I think that is a good point, but I think that I would imagine that when you look at leadership at a firm, you want to make sure that two things are obviously in place. You want to make sure that the person is competent, and then you want to make sure that the person is properly incentivized, right? If either one of those two aspects are not in place, you're unlikely to have leadership from the top that will allow shareholders to maximize their value. If any one of those two elements are not there, then you're likely going to run into.
Then Nell's question, a very good one, is then who gets to make that decision? It should, in her view, I guess it should be truly independent directors selected not by management but by shareholders.
Yeah, and I'm not necessarily, proxy access is a big issue, and that's the idea that shareholders should be able to put their nominees on the company's proxy. I think that's fine, but the main thing is I think shareholders should be able to get rid of directors. And since you brought up the UK, Chris, I'll just say that in the UK, 10% of shareholders can call a special meeting at any time, and once that special meeting has been called, a 50% vote will boot out the directors. Now, I'm not saying that we should cherry pick from the UK or that we should adopt the entire UK system. It's different in a lot of respects. I'm just saying that the world hasn't fallen apart, that they have that rule.
No, the world hasn't fallen apart, but as Chris pointed out, this better, in my view, I'm agreeing with you, this better corporate governance regime has not solved these problems. Britain is having a worse financial crisis than the U.S. You could argue.
Yes, it's still in recession much more deeply than we are.
So there's more. There are a lot of other things going on here.
As I said, there are a million different variables there, including different accounting and the fact that there's so few comparatively publicly traded companies and so few large investors. So it's a very different system.
I think it's also worthwhile noting, when it says who should set pay, that certainly when it comes to, again, financial institutions, systemically important financial institutions, it appears to be that the government will be playing a much more active role. When you recall Ken Feinberg's remarks as to how you defer compensation, for example, when you look again at the Financial Stability Board, one variable, and I mentioned earlier that is more prescriptive than a lot of people say, is that it says that a substantial proportion, it's terms used, such as 40 to 60% of variable compensation should be deferred no less than 3 years, but the deferral period for any particular key employee's compensation should reflect the business, its risks, and the activities of such key employee.
Does the audience know what the Financial Stability Board is? That this is the
this
is the group of 20
international
panel,
panel of governments where you have the Treasury along with central bankers and along with securities.
And it is explicitly a big part of the model for the guidance that the Federal Reserve Board issued here as part of its examination and supervision policy last Thursday.
And that a substantial portion, such as more than 50% of variable compensation, should be awarded in shares or share-linked instruments. This is just to say that certainly there is some degree, if not of conversation, at least of some kind of coordination between Feinberg and obviously national authorities with their international counterparts, but it does at least seem to suggest that there are structural changes with regards to executive compensation that will go beyond even increased shareholder access. That being said, also, it's worth noting that when it comes to global competition and this fear that if we start to regulate here, then we may lose a competitive advantage, it is interesting that we are probably the weakest link in the international global system, right? I mean, actually, just a week after the Financial Stability Board, this brand new organization, sort of issued these statements, the Federal Reserve Board viewed some of the numbers, particularly the substantial proportion number of 40 to 60% in deferred compensation, as as a true common law lawyer would, as illustrative as opposed to as opposed to binding. So what you have are the promulgation of sort of soft international rules, not treaties, and there is a movement for sort of defection. Or non-compliance, and the United States is likely the biggest culprit.
I have a question for Chris, if I may. I spoke to a CEO from India who said to me that the one area of where global competitors felt that the U.S. really had a lock was investment banking, and they said now that we've learned that it isn't really as complicated as we thought, that even America doesn't understand it very well, we're going to really compete. And do you think that the too big to fail element is going to change because we will all of a sudden we've opened up the markets that we used to really control?
That is a really good and very interesting question. Certainly, when you look at what can be considered sort of the democratization of capital, the fact that you have strong GDP growth in certain kinds of countries that have spurred consumer markets and also domestic stock exchanges and capital markets, you see the growth of more and more sophisticated financial services activities in other countries, such as India. The response has been largely, however, one where you see large investment banks expanding by creating international outposts, depending obviously on different domestic rules for convertibility of capital and whether or not financial services are able to establish overseas. So in other words, what you've seen is large U.S. and U.K. institutions and some continental financial institutions grow even larger, right? Often obviously working with sort of local counterparts. It is certainly going to be the case, so that there are certain kinds of financial activities where local individuals are going to have a competitive advantage over foreign competitors. Trading activities will likely be, my guess would be likely be dominated by those people with their boots on the ground in the particular country. But I foresee more international expansion and growth by institutions that are already too big to fail than the prospect of upstarts able to eat into the market share of financial activity institutions. And indeed, when you look at Goldman Sachs and Morgan Stanley and where their profits are coming, I believe over 50%. For example, of these U.S. companies, investment banking companies get their profits and revenues from overseas, which seems to suggest that they are actively participating and competing in these foreign markets. And I'm not necessarily.
Oh, I think that's right. And I think what we're going to see is, as is happening in other countries, our government is going to have to be involved in directing policy for those major institutions to a much greater degree than in the past, because we're going to have so much at stake. We have an implicit guarantee that they can't fail. They're systemically important. There's going to be a risk regulator of some kind, probably two risk regulators, because we always think it's better to have two of everything. Right. This whole idea of regulatory reform is so amusing. We're going to subtract one agency, it looks like, the OTS, and we're going to add two, consumer and maybe three.
That was actually the thing that surprised me most about the administration's proposal.
Yeah, it's crazy.
In fact, I was going to ask Mike what he thought about it.
Whereas, if you look at the major international competition, it's from the huge French banks, it's from the big Japanese banks, it's from Deutsche Bank. Every one of those extremely closely, if not managed, cooperating with and very closely watched by their major government regulator. And we'll see the same thing, I believe, in India, and we already are seeing it in China. I mean, the big Chinese banks are very closely tied to and largely owned by the government, and those are going to be our major competitors. We're going to have to get our act together and have a unified policy. What does that say about shareholders investing in those things? That's a tough question. Are they going to?
Let me from Mike on this.
I was just thinking about. I can remember this is a few years ago, but there would be number of articles in the American newspapers that U.S. only had one of the 10 largest banks in the world, and everybody thought, "Oh my God, they were ready to set their hair on fire." Could not believe this. And it's funny how times change, and most of those banks, interesting enough, were Japanese. And so we've gone from that terrible situation where we only had one of the 10 largest banks in the world to all of these giants that are too big to fail. So if you hang around long enough, you see it all go past. You ask about the regulatory. I think you're referring to the Financial Consumers Protection Agency?
Well, not just that, but that was part of this package of proposals that the administration put out there. And
why did that?
I was just agreeing with John that I thought it was surprising that it seemed to me that little thought had been given to simplifying the regulatory structure. You ended up with a net increase in regulators, even though I think most people agree that the complexity of the regulatory structure was one of the problems that led to bad regulation.
Well, I don't think that's over yet, Clive, but I think that, frankly, that was the whole FCPA issue was about 99.9% political. And that is that the administration and the Democrats in the Congress felt somewhat guilty that they had bailed out all these big institutions. And then the consumer groups came to them and said, "What have you done for us?" And they said, "Well, what about this Financial Consumers Protection Agency?" And that's how it got in the overall legislation. It passed the House committee. I think it was last week, Financial Services Committee last week. Whether that survives in the Senate, I'm not here to predict. But that's why that reaction was there. It had a certain constituent group that they had to take care of.
Okay.
Certainly, when it comes to executive compensation, you'll see both the SEC for the securities firms and the Fed for certainly national depository institutions.
Yeah, the Frank bill would give all the primary regulators power to regulate compensation in context of limiting risk, including the SEC for broker-dealers. Interestingly, people haven't thought about that much. You're absolutely right, Chris. I don't see any sign, though, that the Senate's interested in enacting that part of the bill. I think they seem to be a lot of skepticism about that part of it.
I'm going to take some questions from the audience in just a moment, so be thinking of a question or comment that you'd like to put. I've just got one more question. I would be interested to hear a brief response from each member of the panel on this, and it's stepping back a little bit from the detail of what we've been discussing and the particular issues raised by the financial crisis to this longer-term trend that we've seen towards rapidly rising pay in the finance industry. There's a kind of economic strategic issue here, it seems to me. It's something that Larry Summers has raised in a few recent speeches, that the U.S. has come to depend too much on the financial sector, that the pay is out of line in the sense that it's attracting the best talent in the country to this industry, which has some of the properties of a casino. There's a zero-sum game aspect to what's going on in finance. And is the country wise, as it were, to invest its best talent in this sector to the extent that it is? And then, there's the politics of this, the whole Gilded Age feel, that pay relativities have just gone crazy. That we were talking about this just before, that the difference it used to make between whether you went into finance or into some other profession might have been on the order of a factor of 3 or 6 or 10. Now it's on the order of a factor of 100 or 200 or 500. I mean, what is this something that one should be worried about? Is it a legitimate issue and something we should address ourselves to, or not a matter of concern? What's your view?
What goes around comes around, and that will change. You're already seeing an amazing change in students' choices of their majors and the areas that they want to go into. It's just that happened. It happened in the accounting profession. It happens in the legal profession from time to time. It's a natural order of things that, to a large extent, the government probably ought to just try to stay out and allow that natural consequence to occur, at least it seems to me.
Okay. John, do you have a thought on this?
Well, I agree that it's not something government can command, but it's something we as a society should care about, and care about a lot. To put another plug in for Aspen, Aspen's Business and Society program has developed a curriculum which is being widely adopted in business schools to focus students on social consequences, long-term consequences of business decisions, which I think is very promising. I think as parents and as grandparents, we ought to think about what messages we're giving our kids. As members of society, we ought to think about what we reward and what we praise. I think those are items of individual responsibility. And one of the strengths of this country is that we do take individual responsibility and family responsibility for decisions of that kind. I look at Nell's family. I don't mean to embarrass her, but she and her siblings have all done things which are heavily oriented toward public service, even though they grew up in prosperity and and same thing's true of my kids. Two are teachers. One is a race car driver in China. Don't want to ask me about that. And one works for the Aspen Institute. So I think the values that we put into our children have something to do with the choices they've made. Chris worked in a very profitable law firm. He's bright enough he could easily have gone to Wall Street, and he's ended up at Georgetown. I mean,
you could just tell my students this in about an hour and a half. Oh, I'd appreciate it.
Well, I try to talk to my students here about, career choices are not just about making money.
But this is not for public policy.
I think it's not for public policy, but
tell them that when they graduate.
But I think actually the dramatic layoffs that occurred on Wall Street and the collapse of the investment banker and hedge fund fortunes have been a very useful object lesson, which I think young people take in. We've got great young people.
I wonder if that will stick. But anyway, Chris, what's your take on this?
To get to your original question about, should finance occupy such a large sector of the economy? It is certainly important, and I teach securities reg and international finance, and I certainly think it is important that resources in any country, and certainly globally, are put to the best uses to improve the welfare of mankind. That being said, when you devote such a large proportion of your activities to the financial sector, and in an age where you have financial globalization and you have increasingly mobile capital, in fact, capital being more mobile now than certainly goods, there are certain kinds of risks and implications to those kinds of policy choices, not just at the macroeconomic level in the sense of exposing you to more financial crises, but it means that society at large is making certain kinds of choices as to how it wishes to remain competitive vis-a-vis others, right? Because you have to keep up a certain level of sophistication, a certain kind of investment in education, a certain kind of productivity growth in order to remain competitive in that sector and to dominate it if you're willing to lose, let's say, your industrial capacity. And I am unsure as to the degree to which any country, much less even the United States, is necessarily prepared for the full consequences of having an economy not only driven by finance, but sort of a full range of different kinds of spillovers associated with dominance in that sector, where you have, again, more activities and growth, GDP growth in other countries. And I think it's going to be a challenge for the next generation.
Now, what's your view on that?
This is a great way for us to end this portion of the panel, because I agree with everything that my fellow panelists have said, and I just, I can't leave out the possibility of recommending a movie in my remarks because I have a second job as a movie critic. But I even though I don't agree with everything in it, I think it's worthwhile to see Michael Moore's movie, Capitalism: A Love Story, because he makes a very, very powerful point there that the cost of what we've done to the middle class in this country is pervasive to every element of our society, what it's done to our communities. And so I don't agree with everything he says, and I don't agree with his prescription that we violate the law as a way of addressing the issue, but he does make a really important point. It has a lot of really compelling numbers about what we've done to the middle class, and I think that's something we need to focus on.
Okay. I'll see if there's any questions from the audience. Sir.
Or comments.
Could you, I wonder if you could, yes, or comments, indeed.
Hello.
Oh, Meryl, you've got one. Okay.
Yeah, I do. I have one.
We'll come back to you in a moment. Come back to you in a moment.
Oh, Bill.
Bill Coleman.
Okay. Okay. All right. Well, Judy Samuelson and Business and Society program, and you as a signatory, John, came up with this very interesting report, very persuasive report about short-termism, and there it is, and I have my copy as well. There's an enormous difference between the interest in a corporation of the day trader who's in for 24 hours, of the corporate executives who, at least according to what Mr. Feinberg was talking about, maybe are in for 2 or 3 years, and the investors who may be in for 2 or 3 years. And then the investors who are in the sort of the old-fashioned way, you know, for a 10 or 20-year time frame and are putting their retirement money into it. And my question is there some way for us to deal with the kind of short-term thinking that results from the influence of the day trader, from the influence of the short-term, perhaps very large investor, versus the interest of long-term investors in company? Is this something we want to push? I mean, do we want to push more to have long-term investment strategies be the dominant strategy? And how do we balance those interests?
Well, this group, which is, if you just take it alphabetically, from Bogle and Buffett at the top to Wilcox and Wolfenson and Trumka at the end, and Hiram Elstein and Jay Lorsch, who's out here in the audience, and I are sort of in the middle. It's a very diverse group, and we tried to come to a consensus as to how one might address these issues. And I think it's impossible to manage an enterprise or to set government policy based on satisfying the objectives of any one of those groups you mentioned: the day trader, the short-term investor, the hedge fund investor, the event-driven investor, the Carl Icahn or the Nelson Peltz, and the long-term pension fund or retiree investor. They have different time horizons, and they're always going to have different time horizons. The way to encourage longer-term management decisions, which are for the good of the economy and the good of the enterprise, are to focus on the long-term value of the enterprise, no matter who's the owner at the moment, and also bearing in mind that there are other stakeholders that are important, particularly if you look at the example of the automobile companies and currently the financial institutions and so forth. The current stakeholders are heavily us as taxpayers, either both as equity owners and as creditors. But I think that managers have to manage for the health of the enterprise, and that's what the corporate law increasingly is deciding. Now, having said that, what does that mean? What's the term? There's a lot of thinking on that. With respect to federal policy, we've suggested consideration be given, I'm not saying that it's going to happen, to returning to a situation where long-term investment is rewarded by having a lower capital gains rate for people that have a longer holding period. That's a fairly simple change. We've also suggested consideration be given to an excise tax, a very small one, on frequent trading, so that people who are trading all the time, may have very good strategies and so forth, will pay some of the societal costs of that. Those are quite controversial. There'll be a lot of pushback from Wall Street and others on both those concepts. They may not happen, but that's the kind of out-of-the-box thinking. We had that system at one time. So there are a number of things one can do with respect to investor intermediaries. We've suggested that there could be, as there is to some extent in the Investment Advisors Act now, some regulation of how intermediaries are compensated. So like corporate executives who compensated on a longer term time horizon, intermediaries ought to be compensated on the basis of their long-term performance as opposed to what they did this quarter or what they did this year. And those are all things that can be done by a combination of investor, shareholder, voter, and government initiatives. And they're not easy, but our thought is that they ought to be addressed because the way things are happening now, we have too many decisions driven by short-term goals on the part of all people concerned.
Any other thoughts on that before I take another question?
So it's kind of idealistic, I know, but sometimes this is an opportunity, we think, to step back and be idealistic.
I just will say that if shareholders, it's a chicken and egg thing. If shareholders felt that they had more of an influence on directors and pay and all those issues, I think that they would tend to have less turnover. And I also think that it's up to each company. If a company wants to issue stock that gains voting authority, the longer you hold it, let them do it. Let them put it in the market.
Which is something that is somewhat heretical for some of your colleagues.
I think you're next, so perhaps you could come down to the mic if you don't mind.
It's a very distinguished questioner, Secretary Coleman.
Maybe someone could take the mic to Mr. Coleman. Thanks very much.
Thank you. I'm Bill Coleman. I'm a lawyer in O'Melveny and Myers. I think this has been a great discussion, but before you change everything that's happened, one ought to look at the situation. First, Feinberg's a very able lawyer, but to the best of my knowledge, he never sat on the board of a major company. He's never practiced law in one of the law firms that represent them. Secondly, as I understand it, the statute saying that certain companies would get money was passed certainly before there were all these conditions about changing pay. Thirdly, believe it or not, some of these companies have very able people, and they make deals which make over $1 billion for the company. And therefore, to say that they should get a $30 million bonus isn't as foolish as you think it is. I realized that when I first became a partner in my first law firm, I think my first year take was $17,000. I now know in our law firm this year, when we took in 9 new associates and partners, each one got a guarantee of $500,000 plus a bonus. And if you go to the world's really changed. And until you realize that, I don't think you should make it. I think one of the great tragedies, I can't name 3 senators in the Senate that ever really had any business experience. There are very few legislature. You talk about the automobile industry. What really happened was the governor of Tennessee was visited by a Japanese company. He gave them the land. He let them build a building-grade course. They then start putting out automobiles, paying their laborers 35% less than those paid in Detroit. So obviously that made a difference. And all I'm saying is that as you look at this, look at it more than just like a scholar, but please talk to some of these businessmen that made it. And finally, I think I'm right. Do you realize that by saying that those people could get a bonus of over $1 million instead of the 30 or 35, that you deprived the government of their tax return of 35% of what they otherwise are giving you?
Well, thank you very much. I think that's a comment more than a question, but please, if there's any response to that, let's go ahead.
I have no problem paying somebody $30 million for closing a deal that makes billions of dollars. I have a problem giving him $30 million when he actually makes a deal that loses a lot of money for the corporation. And I think that's what we have now. You know, you're never going to hear me complain about Bill Gates's pay or Warren Buffett's pay, or you know, we tend to find in our database that founders are generally paid in the right way. It's later on when people say, I won't even walk in the door unless I get a $50 million signing bonus, that you're really running into trouble. And Bill, if every board of directors was like you, then I wouldn't have a problem.
You know, I want to, because I wonder a bit about what happens. Pay when you have a $30 million deal or a $5 billion deal. To make $5 billion for a company, either you're a Bill Gates or you are working in an institution where there are such economies of scale where you can secure such profits, right? So I wonder sometimes when you talk about the sort of the importance of any person, whether or not there's an economic model where you can derive, you know, or associate that kind of pay almost necessarily to institutions that are too big to fail, right? I also this is a remark because
and the inherent subsidy that implies.
and the inherent subsidy that implies.
I'm reminded of the examples of Fannie and Freddie, which are now permanent wards of the state, and where there were very, very heavy amounts of compensation paid for what looked to be extremely profitable decisions for a while.
I want to add something to the very nice introduction that Clive gave to me before, which is that in addition to what he said, I'm also a serial entrepreneur, and I am now in my third company. We sold the first two successfully, so I've met a payroll, and I have had to make a lot of these decisions myself, and I'll tell you that nothing makes me happier than when my sales guy is the highest paid person in the organization, because that's good for everybody.
Right. More questions? Yes, please.
I want to ask you to follow up, Mr. Olson, on this issue of pension funds and institutional funds as an intermediary, so to speak. Been so distracted by the big companies, and rightfully so. What about the responsibilities of these folks that do the investment? Knowing, having represented some, I'm sympathetic that they're trying to put pressure on boards. But by the same token, I sometimes hear them whining, oh, we're victims of all this, when their huge funding power their huge funding power is creating this pressure for short-term results that swamps in pay issues. And I'm wondering if there's a way that maybe some of these structural reforms aimed at corporations could be incentivizing big pension funds and others to really think long-term, because they've got 20-year-olds now that they're going to be paying pensions for in the year 2020.
I think this is a crucial.
Hey, he asked me.
Sorry. I just have to say, I just have to say, when I met with Secretary Geithner, and John was there, I said, where's the Labor Department? They preside over the largest accumulation of investment capital in this country, and no one has ever said to them, could you please behave like a grown-up instead of like a greedy child? And I completely agree with you. Now, John.
Well, you said it all. No, I agree with that. I think that the Department of Labor, which administers ERISA, has the opportunity and, frankly, the responsibility to do something about the way pension fund managers are compensated and how they're incentivized. And I don't mean to keep picking on CalPERS, but they've been in the press a great deal lately. They made a series of disastrous investment decisions with respect to alternative investments and with respect to portfolios that they invested with. And they are among those who funded the folks on Wall Street who did the things that we're now complaining about. And it appears that they did it in a system where people who were cronies of members of the board, which is politically appointed, got paid millions of dollars to recommend investments for them, much as happened with the New York state funds, which are being investigated by Attorney General Cuomo. I think it's a very, very serious problem. And I think, unfortunately, I'm a Democrat. I voted for President Clinton twice. I voted for President Obama. I'm not a member of some labor unions from when I worked as a kid, starting at the age of 11. I'm not against the union movement. I'm not against the policies of this administration. But I think, unfortunately, the politics of my party and of this Congress are that we're not going to deal with this issue. And I think that's a great tragedy, because it's going to be viewed as an attack on employees and on the labor movement. And it's a scandal that continues to unroll and will continue to unroll until we impose some real standards on who can be ERISA fiduciaries and make them serious.
CalPERS's decisions were no worse than the Harvard endowments.
No.
Didn't have any of those problems.
Yeah, but the difference is Harvard endowments worries those of us, including your sister who's the dean of the law school and me as an alum, about funding that institution, but it doesn't affect retirement of any of masses of people.
You know, I actually,
the way the public employee fund.
I'm just talking about the susceptibility. You're changing the point. I'm referring to your point on the susceptibility of making bad decisions. And by the way, the people at CalPERS do not have incentive compensation, as Dale Hansen used to say. I get paid $100,000 in a good year, and I get paid $100,000.
No, their problem there, I think, is it's a
that's not working too well.
No, it's not working well, and it's a politically dominated board, and a lot of good people have left CalPERS, and some people we know and could name over the years because they were frustrated by the politics there. And that is a problem in every single government pension fund in the country, with very few exceptions.
In law schools, it's a problem in corporate. I mean, those kinds of.
But what don't you want to? But you agree we should address those problems, right?
Sure.
Chris, you had a comment.
No, only because I 2 weeks ago last week. I ran across a former CEO of CalPERS, and his argument, which by the way I don't buy, but since everyone's going to pile in on them, their argument is obviously that pension funds don't have the flexibility, even when it comes to negotiations of corporate policy vis-a-vis CEOs, that other kinds of funds and financial intermediaries have. That they are so large and so big that the space, literally, for their investments, and because it's often tied to different indexes, that they can't move their money to the same degree and in the same way that other kinds of funds and institutions can. Right. Therefore, their bargaining power vis-a-vis CEOs is less. Now, I from a theoretical academic level, I identify. But as someone who's worked on deals before, and I've seen sort of interactions, I think that he may understate the influence that CalPERS or any particular pension fund has. But that is just to put it out there, okay. the argument.
Sounds like a case of being too big to succeed. Mike, do you have a view on this pension fund issue?
Yeah, but I think we're getting off track. So let's get something that's we're talking. This is all about executive compensation. I think we ought to get back on track.
All right. Well, let's see if we've got another question.
I'll submit a brief on the other one.
The conversation we've been having today, as you say, is on executive compensation. But in financial institutions, I found that a lot of the day-to-day decisions about who takes on risk, et cetera, and what risk to take on are made by people more in the mid-level. So do you see any role for regulation, not for amounts, but more for structure, and to see, how much of their compensation can be bonus? Because a bulk of the compensation for these mid-level people does come from bonus.
Right.
So do you see a role to put in place a structure?
I see a role for disclosure, yeah.
Well, actually, that's what the Fed's principles are aimed at doing. They're aimed at the entire compensation structure of the financial institutions that they regulate, consistent with the Group of 20 approach. So we'll see how that works. It's a big job. And as Ken Feinberg just said this morning, when he goes from 25 to 100 in just these 7 companies, it's a heck of a lot of work for a regulator to understand what's going on. But you're absolutely right. I mean, many bet the company type decisions end up being made by middle management or by managers of particular functions, and how they're compensated and how they're supervised are very important issues.
Any other comment on that? Well, I'll take maybe one last question. We're almost at the end. Is there another question out there? I thought I saw another hand, but no. Well, I think we'll wrap up. We've come to the end of our time. I just want to thank the members of the panel for what I thought was a very interesting discussion. I enjoyed it very much, and thank you all for coming.
Doing some panels.
See you again. The last time we saw each other.